This is Michael Popok, Legal AF, the sideshow that has become the attempt to disqualify Fulton County District Attorney Fani Willis has taken another turn. Yes, the judge has set a March 1st hearing date for a final hearing as to whether, based on the evidence, mind you, that he has heard or will hear, whether there is grounds to show that the prosecutor, Fani Willis, is financially incentivized and biased against Donald Trump because the person that she dated for a short amount of time is also on her special prosecutor team and leads against Donald Trump. There are grounds to disqualify a prosecutor. These don't seem to be those. All this seems to be, and unfortunately Judge McAfee has allowed it to happen, is an attempt to disparage, undermine, and professionally injure and hobble Fani Willis and Nathan Wade to make their prosecution of Donald Trump off an indictment that was rendered by a grand jury of his peers, of Trump's peers in Georgia, to make it delegitimized, to make it to undermine its credibility or its integrity. That's all this is about. Now we're fighting over the phone records. The only reason we know about the phone records is Donald Trump violated the standing order of Judge McAfee on how expert and other evidence is to be presented in court. And all of a sudden, at the last minute, posing as proposed Exhibit 38, which sounds innocent enough, except when you get to the bottom of it, it is the work of an investigator, not an expert. Not even Donald Trump has said he's not an expert. A guy named Charles Middlestat, who put together some analysis, some pseudo-science related to cell phone tower pinging and triangulation to try to determine if Nathan Wade was in the same proximity as Fani Willis's apartment at any given moment, and whether Fani Willis lied to the judge about the timing of when her relationship with Nathan Wade started, before the indictment or after the indictment. First of all, let me tell you, as a practicing lawyer, cell phone tower data is inherently unreliable, and many courts don't accept it. Law enforcement might use it as part of a tool, as an investigative tool, but it being used in court successfully has usually been found to have minimal value, especially when Donald Trump himself in his own court filings has said that the person he used, Charles Middlestat, is not an expert and is not being used as an expert in this case. Now, the only reason they did that is to try to get around the standing order of the judge, literally an order that says if you're going to use an expert, you got to give notice to the other side. You have to tell them of the qualifications of the expert, including if they've ever been qualified as an expert by a judge before. Because not just any expert gets to walk in the back door of a courtroom and testify in front of a judge or a jury. Only a special breed of credentialed people get that benefit in a courtroom. Notice, qualifications, the evidence that's going to be presented, and a summary of their opinions. Well, Donald Trump did none of those things. He just leaked to the New York Post and other papers a filing that suggested, and now it's run wild, that Fani Willis and Nathan Wade were in some sort of salacious embrace in her apartment at 4 o'clock in the morning based on cell phone data. Cell phone data that can't tell you generally where exactly in the tower network a certain phone is. And in the metropolitan Atlanta area, for instance, the distance between Nathan Wade's phone and Fani Willis, there's thousands of businesses, restaurants, the airport, and everything else. And you can't fine-tune that GPS to say he was in her apartment on a date certain or brought her dinner on a date certain. Look, he already testified, Nathan Wade, that probably a dozen times he went to her apartment, generally to talk shop, and sometimes after the relationship started for other things. Who cares? This has become an entire sideshow. Or to use the parlance of the judge, this is not the core facts in the case. This is not the core issue in the case. But Fani Willis fought back, and she just filed, I'm going to read for you, a really strong attack to have all of this cell phone data, as unreliable as it is, dismissed, precluded from being introduced into evidence under two standards. One, it violated the judge's standing order, as I outlined. And also there is a standard for all experts in federal court, civil or state, that they have to get over. It's a line of cases that starts with a United States Supreme Court case in 1993 called Daubert versus Merrill Dow Pharmaceuticals. In the business, we call it the Daubert motion or the Daubert standard. Before Daubert, there was another standard. It was a weaker standard. It was called Fry. It was based on another case. But under the Daubert standard, there are criteria that have to be met for science or pseudoscience to be introduced into evidence. Now, Donald Trump is afraid of the Daubert motion and to have Charles MeidasTouch excluded and his data along with it. So he said in his own filing, he's not an expert, basically conceding that MeidasTouch should not take the stand, because this is how it works in a courtroom. There's only two types of people that can take a stand and literally and testify. Lay witnesses, which we call precipient witnesses with knowledge, because with one of their five senses, they are able to obtain a fact and they can testify. And then on a very limited basis, they can testify to some opinions based on the facts that they observed, but on a very limited basis. The only other person that can take the stand in a case, civil or criminal, are expert witnesses, but they have to qualify as an expert witness. Then there's this, I guess there's a third, there's a subcategory of what we call records custodians. And those are people that, work for companies. They're officially designated by those companies to be responsible for record keeping. And when we subpoena in the business, in law, we subpoena third parties, for instance, like the phone company, the cell phone company, and things like that. They have to authenticate those documents, and they do it by way of providing a records custodian. So records custodian witness, lay witness, fact witness, if you will, and expert witness. That's it. And he has to fall into one of those categories, Charles MeidasTouch, or he doesn't take the stand at all. The problem that Donald Trump has is they have this whole mound of pseudoscience cell phone data, which, as I demonstrated to you earlier, based on expert reports that have been produced, they are very rarely able to pinpoint with proper accuracy sufficient for a courtroom whether two people are in the same room or house or building at all. In other words, Nathan Wade could have been at his favorite restaurant 2 blocks away, and he's still using the same cell tower as Fani Willis and her apartment. And as I said, there's thousands of businesses and the airport within these tower ranges. So they have a batch of evidence that they wanted to get in, but you got to get it in through somebody. And so you can either bring in the AT&T cell phone person, and all they can do is just establish the pings, if you will. But they wanted Charles MeidasTouch to summarize the data. There is no such thing as a summary witness for data collection or evidence. It's improper. It's an improper opinion testimony by somebody without precipient knowledge, and it should be banned and barred by Judge McAfee. Also, to the extent that MeidasTouch tries to take the stand as some sort of expert, or they try to qualify him, he doesn't meet the Daubert standard that I just described to satisfy being an expert. So she's completely right. And then she calls it out for what it is in her filing. She says this is just an attempt to smear her in the paper and the press and to have a media campaign to try to undermine the credibility of the office, and has nothing to do with evidence or proper grounds to disqualify her. Let me read to you from what is docketed as the state's objection to and motion to exclude defendant Donald John Trump's, not President Trump, Donald John Trump's proposed supplemental exhibit 38, submitted in violation of the rule that I told you about, Daubert, and the court's own standing case management order for criminal cases. And here's what she said. First, she said defendant Trump's proposed supplemental exhibit violates this mandate of the court in 4 ways. His standing order. Defendant Trump provides no written notice to the state, provides no summary of the purported expert's testimony, provides no information related to qualifications of the witness to serve as an expert. That would be MeidasTouch. And no notice was provided at least 7 days before the evidentiary hearing that began on February 15th of 2024. Because that was the start of the hearing. March 1 is the continuation of the hearing. And they also note in their filings on page 3, that the lawyers for Donald Trump and Mike Roman, have been in possession of the response from AT&T to the cell phone data subpoena since before the hearing, somewhere around February 9th. They had plenty of time to give that notice. They go on to say in the filing, As I said on page 7, they go on to attack the pseudoscience, and I use science in quotes, around cell phone data. They say on the bottom of page 7 in their filing, the records do nothing more than demonstrate that Special Prosecutor Wade's telephone was located somewhere within a densely populated multiple-mile radius where various residences, restaurants, bars, nightclubs, and other businesses are located. In bold, the records do not prove in any way the content of the communication between Special Prosecutor Wade and District Attorney Willis. They don't prove that Special Prosecutor Wade was ever at any particular address or location. They don't prove that Special Prosecutor Wade and District Attorney Willis were ever in the same place during any of the times listed in the supplemental exhibit. And in fact, the brief goes on multiple relevant dates and times, evidence clearly demonstrates that DA Willis was elsewhere, including, as she says in her brief, at work at the Fulton County District Attorney's Office and, all caps, all bold, and visiting the 3 crime scenes where a mass murder motivated by race and gender bias had taken place. And she submits as Exhibit C her calendars and emails showing where she was at any given moment in time on page 8 of her brief. But then she calls it out for what it is. What she says is, in Roman numeral 4, the argument on page 8, Defendant Trump's proposed supplemental exhibit, which is clearly inadmissible with no or little evidentiary value, was not filed in good faith and is simply another attempt to garner media attention. Attention, Judge McAfee. The state, as the brief continues, submits that Defendant Trump's proposed exhibit was not filed in good faith, but is another attempt to garner salacious headlines in the media, and she attaches one in particular, a New York Post article from as Exhibit D in her motion. Some of these headlines, including the attached, were patently false, and many others were misleading. Roughly simultaneous with the filing, counsel for Defendant Trump immediately provided unredacted cell phone records which contained personal identifying information belonging to Special Prosecutor Wade and DA Willis to members of the media. See Exhibit A, Steve Sadow, the lawyer for Donald Trump's email. Portions also include other identifying information. So let's go to Exhibit E towards the back here. So the calendars we just looked at. And so under Exhibit E, apologizing apparently by saying, hey, I inadvertently sent the unredacted cell phone records to Bill Rankin this morning. When I realized the error, I immediately contacted him. He's in the media, and told him explicitly not to disclose them to anyone else and not to publish the cell phone numbers or other protected information. Mr. Rankin indicated he understood and would not publish the cell phone numbers. It was my mistake alone. And then Citizens Free Press in Exhibit F uses a heat map, which is also misleading and pseudoscience, but they published it anyway, to show that in a heat map of Fani Willis calls and texts with Nathan Wade, that there were 2,000 voice calls, 9,000 text messages, and heavy concentration after hours, 7 days per week. And we know that's not true, and that is not what the data analysis will show. So we'll continue to follow as we lead into March 1, which is the hearing where, God, please, the judge here, Scott McAfee, put an end to this charade and end it once and for all. Find no grounds for Fani Willis and Nathan Wade to be disqualified and set the case for trial. We've complimented Scott McAfee at various times on Legal AF and on the MeidasTouch network for what we thought was an even-handed, sober, judicious approach. But at the moment when character matters and judicial ethics matter, I question how he's been handling this particular case. As I said in a prior hot take, the way I think it should have been handled is that he should have held the motion hearing on the legal standard, allowing the lawyers to make what's called a proffer of what the evidence would show if they're ever able to put it on. And the judge can then make a decision as to whether the proffer is sufficient to satisfy a prima facie case to disqualify DA Willis. And if it wasn't, then there should not have been actual live testimony, and Fani Willis shouldn't needed to have testified in her own defense. But that ship has sailed, and we are now, we'll jump from that bridge when we get there, and that we're getting there on March 1st. He can now fix this problem. And then my other criticism of McAfee is that he's got to set this case for trial. The more, idle hands are the devil's playthings. And the longer you give Donald Trump, Mike Roman, and 14 other co-defendants, to do their mischief and file motions like this, the worse that we are. Set the trial, Judge McAfee. You're not going to dismiss the indictment of the case because of this, and you shouldn't disqualify anybody because of it. Let's get to it. Deny the admission of Exhibit 38. Deny Mr. MeidasTouch taking the stand as an expert for the defense, and reaffirm and rehabilitate the reputation of Fani Willis in doing so. And let's get to the matter at hand, which is the prosecution under an indictment rendered by a Georgia grand jury of Donald Trump and others for the election interference case for which they are charged. We'll continue to follow it on Legal AF on the MeidasTouch Network, Wednesdays and Saturdays at 8 p.m. Eastern Time, and then on audio podcast platforms of your choice. So until my next hot take, give me a thumbs up here, leave a comment. It helps with the ratings, keeps us on the air. Till my next Legal AF podcast. This is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.